Welcome back, everybody, to co-ownership. This lesson we're going to talk about the idea of severance. Now, you can really divide the topic of severance into two different distinct categories. On the one hand, you can talk about what severance is, how it works, and do a few examples of how it works. That's what we're going to do in this lesson. And then you can talk about the ways in which it works, how it works, i.e. the process by which it works. That's something that we're going to do in the next lesson when we start talking about the methods of severance, the different ways in which you can sever from co-ownership of a property. This lesson, though, like I said, is just going to talk about severance from an introductory perspective. We'll take an introduction to what severance is, get a general idea of what we mean when we talk about severance, talk about where severance can or cannot apply, where it is able to apply and where it is not able to apply. And then, as I said, in future lessons time, talk about the methods of severance. So, whenever you have a problem question on the nature of co-ownership, for the most part, you'll probably be examining the idea of severance. You'll likely be examining the idea of severance. This is something that is a very popular question for those who are setting exam questions on the idea of co-ownership. Severance is often a topic that is discussed quite a lot because it's quite a substantive topic that has quite a lot of interesting details attached to it. And so this lesson, like I said, is going to introduce this idea of severance before then talking about the methods of severance in future lessons' time. So what is severance, and what do we mean when we talk about severance? Well, it is the process by which co-owners of a property may make the decision to change their legal title to the property, which arises from a joint tenancy, to that of a tenancy in common. That's initially what we think when we talk about severance. According to the Law of Property Act, the severance of a joint tenancy cannot happen at law. And so when we talk about the severance of a joint tenancy, it only happens in equity. This is what we see here in section 36, subsection 2, where they say that no severance of a joint tenancy of a legal estate, so as to create a tenancy in common in land, shall be permissible, either by operation of law or otherwise. But this subsection does not affect the right of a joint tenant to release his interest to other joint tenants, or the right to sever a joint tenancy in an equitable interest, whether or not the legal estate is vested in the joint tenants. So the process of severance and the idea of severance is essentially taking your joint tenancy and removing yourself from that joint tenancy to become a tenant in common, to become part of a tenancy in common. And like I said, this is not operational at law. It can only happen when we talk about equity, and it only happens in equity. We'll explain what this means in a second. But the process of severance is very, very interesting. Essentially, when a co-owner severs from a joint tenancy, they will then have an entitlement to a distinct and separate share to the property in the form of the tenancy in common. So if you remember back to previous lessons, when we looked at the distinction between a joint tenancy and a tenancy in common, we concluded that the joint tenancy is this idea of there being a single unit of ownership, whereby you have different people who are co-owners of the property, but they together are a unitary group that represent a singular joint ownership of that property. And we noted that in order for this to be achieved, you have to have the four unities of possession, interest, title, and time. But then we also noted that when we look at the tenancy in common, there is a divisibility that is necessary, or there is a divisibility that is present in that particular relationship, such that there can be a distinct and separate share of the property that is exhibited by each of the co-owners of that property. And we also noted that when we talk about the tenancy in common, there is only the requirement of the unity of possession. The other unities are not required. They are not necessarily they're not necessary, should I say, for the existence of a tenancy in common. So if we had a scenario where you have a joint tenancy, which remember is limited in law to 4, okay, there has to then, and somebody wants to make the decision to sever, what that decision is going from being a joint tenant, going from being somebody who is part of a greater whole, part of a greater group that all represents a unified group of ownership, to having a distinct and separate share of the property as they devolve from being a joint tenant to a tenancy in common. Now, this is a process that can only happen in equity, okay? It can only happen in equity. It does not exist at law, owing to Section 36(2) of the Law of Property Act. So, when we think about this, it says here that no severance of a joint tenancy of a legal estate so as to create a tenancy in common in land shall be permissible, whether by operation of law or otherwise, but this subsection does not affect the rights of a joint tenant to release his interest from other joint tenants, etc., etc., etc. It can only happen in equity. It cannot happen in law. Let's take the following example. Let's see what I mean when we talk about the process of severance, and then we will get to the methods of severance in the next lessons. Well, if we have three people, person A, person B, and person C, and these were all joint tenants in the property, and they hold the property on trust for themselves as beneficial joint tenants, we have this relationship. They have rights in law as a joint tenancy, and they have rights in equity as a joint tenancy. Okay, you have A, B, and C, both joint tenancy. Remember, when we think about rights in law, okay, rights in law in co-ownership can only ever be exhibited through a joint tenancy. However, rights in equity can be either a joint tenancy or a tenancy in common. So if we're talking about rights in law, you're talking about a joint tenancy. If you're talking about rights in equity, then you're talking about either a joint tenancy or a tenancy in common. In this particular example, A, B, and C are all joint tenants in law, but they also hold the property on trust for themselves as beneficial joint tenants, i.e. they have rights in equity as well. What about then when we see the decision to sever? Let's say C goes and says, I want to sever. Okay, we'll talk about how they may go about that process in future lessons' time, but let's just say for now we know that they make the decision to sever. This is what happens, okay? We still have the same rights in law. A, B, and C still have the same rights in law, and they are still joint tenants in law. This is obviously because severance does not affect legal title, as per Section 36(2) of the Law of Property Act. But the rights in equity are a little bit different. You have A and B on this side here, and then you have C on this side over here. The reason why this has happened is because what has happened in equity is that the joint tenants have been split. You have the two joint tenants of A and B, the people who've decided not to sever, but then you have C over on the other side. And that's because C has decided to sever and has reduced their rights in equity from a joint tenancy to a tenancy in common, thus therefore representing a distinct share. So when we talk about law and the rights in law, there is no difference. Severance only is effective at equity, and so it does not make any sense to suggest that this happens in law as well. We know this from Section 36, subsection 2. So when there is a decision to sever in equity, you no longer have a joint tenants with all three parties. You have A and B on the one hand being joint tenants, they're representing a distinct single unit of ownership, but you then have a tenancy in common, this being represented by C.